from the Chief Justice. Ladies and gentlemen, the Honorable Maria Lourdes P.A. Sereno, Chief Justice of the Republic of the Philippines.
Good afternoon, everyone. I thank you for coming and sharing your precious hours in the afternoon with us. This will be the second time that I will be holding a session with the press. And actually, I found last year's session very useful, even for me personally. I hope that we can take this occasion to use these moments for me to be able to share with you a vision of the future in the judiciary that awaits the Filipino public. What is that future that I envision? Not only am I going to give you a state of what is happening right now in the judiciary, I would be even showing you a picture of events and reforms that are going to be launched and are indeed taking place right now, some of them, as early as next month, next quarter, in 2015, and all the way up to when the retirement comes for me. First, I would like to tell you that, and in Quezon City, who will simultaneously start conducting continuous trial in the system. And this will be launched next month, and I hope to see many of you there again. Now, for some of you who are practitioners here, and Dean Santa Maria is one very important figure in the legal landscape right now, you can imagine already how revolutionary the concept of a Philippine court that is conducting trial on a continuous basis can be. In other words, we have drugs cases where litigations, where the hearings can be conducted on a daily basis. A drug case, the main trial of which can happen, can be terminated in as early as a week, and maybe the decision can happen in as early as 6 months to a year. So no longer will you have an accused who has to wait for 4 to 5 years in detention because he cannot afford to post bail, or in some instances, the offense against him is non-bailable. He will then have a chance to immediately have the resolution of his case terminated. If we are successful with this first batch of 25 volunteer courts, we hope to replicate that. This will impress on people the fact that to bring this about requires a lot of resource contribution, not only from the judges and the participants themselves, but the national government. If we are going to make this come alive, then the national government must give us the necessary support for this to come about. We have 25 this year who will begin conducting a continuous trial. If we can hit 100 courts by next year, that will already be a fundamental change of the landscape. By the end of 2016, maybe we can have about 500 courts participating in a continuous trial system. And if it becomes the normal litigation process, we will have strengthening of the alternative dispute resolution system, and that is happening even right now as I speak. Now, let us picture for you, for example, a commercial litigation. Now, many commercial litigations take about 5 to 7 years to resolve at the trial stage. Now, what I envision is, unless the litigation is inherently complex, such as in antitrust cases and class suits where you have hundreds of plaintiffs, then normally it should take no more, even for a commercial dispute, to be resolved within a window of 2 to 3 years. If you can then assure investors that in 2 to 3 years' time, your contractual dispute, your breach of contract problem can already have a resolution from a trial court, then the investment framework, the investment formula that they are using will already factor that in. And it will not be considered as two. As we can make such programs, such platforms accessible to enough number of people, we will continue to push the boundary of what can be done. The importance of this is not simply on the matter of convenience of the lawyer or the litigant, who does not have to go to physically trudge all the way to Padre Faura to have his pleading filed in the Supreme Court, or to Orosa in the Court of Appeals, or to whichever trial court that the pleading should be filed with. That is not the only point. The point also is we are trying to minimize the carbon footprint that the judicial processes actually impact on the planet, the effect of climate change. So disaster resilience is important in our infrastructure development programs. We know what happened to our courthouses in Tacloban, where all our court records were inundated. Some were reduced to the consistency of paper mache. So you can, constitution of all those records are really disastrous to the cause of justice. So what we have to do is to find a way of storing our documents so that they are not lost to the ravages of disasters such as floods, earthquake, and men and women who are committed to living lives of uprightness and excellence. And we are already thinking very seriously out on how to capture that quality at the earliest stage possible so that we can set them apart. We can breed them to be immune to societal and political pressures. We are trying to depoliticize the system of appointments and selection and training and assignments as much as possible. Because the idea is that it is up to the judiciary that who must to establish the gold standard for public service. And you cannot have a gold standard upheld unless you first start with the men and the women who will populate the ranks of the judiciary. Now, may I go to what is happening right now on the ground? You know, we met last year when the e-court system was launched in Quezon City. And I would like to tell you that there are now 61 pilot e-courts. From the moment we met in June last year in Quezon City, there are now 61 fully operational pilot e-courts. And additional rollout trial courts are being made. Now, as long as the incidents are entered on a daily basis in the system, reports are already generated automatically. This will do away with a period of 1 month, which is the total amount of time it takes to manually inventory the cases. So we save 1 month of productive time. And then there is a dashboard that the judge himself, and this dashboard is connected to that of the executive judge, where he already has an idea of the ages of the cases that he is handling. So the priorities to him will be quite clear. The dashboard will also tell him how many detention prisoners are still there. So he can seek to focus on the detention prisoners so that we not only solve the problem of congested jails, we are also very cognizant of the liberties of the accused that must be preserved because there is no finding of guilt on him yet. It also increases public access to information. Right now in Quezon City, you just go to a kiosk, share already the collection of forms that have been arrived at by justice. We are going to share that with the rest of the public so that precious time is saved because we don't really always have to reinvent the wheel. When a template is there, there is no crime, there is nothing wrong with using the template if it is useful and available. Now, that can only succeed, of course, when we are trying to push the agenda of reform. If, in the first place, a judge is given a reasonable caseload. Now, you will probably be surprised, but the truth is there are courts in our country which have only about 30 cases apiece. On the other hand, there are courts that I have found that had as many as 4,000 cases. In Quezon City, the highest number of case docket that I found was 2,200 for one drug court, first-level trial court. Now, this is an unreasonable caseload, as any human will probably tell you who has worked with cases. We are thinking of bringing it down to a level where judges can look forward to a work-life balance. We thought initially that 500 supervision of the judicial staff, judicial supervisors of the Office of the Court Administrator gives suggestions for the court to either archive, dismiss, expedite proceedings, or even come up with the suggested resolution already of the case. This has resulted in a dramatic improvement in Quezon City, where we launched the Judicial program. The Judicial program is, again, a program funded not by GAA money. We don't have support for judicial reform programs from the GAA money. It is funded by the USAID. So the USAID funds the lawyers who are bound by the confidentiality agreements that we have made them sign together with the paralegals. And many of them come up enough so that they are devoting time and then time to those case inventories and case management proposals. And then you have private courier service being utilized by these courts. Now, these figures point out that from the time we launched it in 2012 until May 2014, it has already resulted into a 28.84% reduction that we are not deploying. It's not a single track solution. Now, we have the problem of jail decongestion. I think some of you were able to join me when I visited some of our jails. And you already know that the proportion of overcrowding is 1:4 in some cities, 1:8 in others. It is as bad as 1:10 in others. And it is true. The rotation system for sleeping on the floor in a detention center is really the norm now. And I've seen this in all the cities I've visited, and nobody denies the severity of this problem. So what we are now doing is we had launched a jail decongestion program by issuing guidelines for decongesting these jails. Now we are going to put further emphasis on what can be done by the judge. First, by prioritizing his bail hearing, allowing more releases, not on the basis of financial capacity to put up bail, but rather on the testimonials given by reputable organizations who can assure the presence of the accused during trial. We are also authorizing the service of subpoena and notices through email. The judge sends an email to a designated address controlled by the PNP Central Headquarters, together with the same email sent to the local police station where that police is designated. The sending of the email and the acknowledgement of that email by the system, which is automatically generated, is already service of a subpoena. So that if the policeman does not come, and the judge deems that there is an unreasonable non-appearance of a key witness, then already the defense lawyer already knows what to do. We guard the rights of the accused so that the accused is not unduly prejudiced simply because key witnesses against him or her have not appeared. And the system is such that because it is received by Central Headquarters, a report is immediately made on whether he has attended the court hearing as required by the subpoena. If he has not, it is automatically alerted to the administrative organization within the PNP so that the policeman knows that a court process is such a serious process that if he feels about schedules being coordinated, about using the same terminology, using the same platform in order to identify evidence, etc. So you don't have the inefficiencies brought about by 4 different sectors talking in 4 different languages. You don't have that. So we are going to maximize efficiencies while being very cognizant of the need to preserve judicial independence at all times. Now, you have already, we have had the e-Jow system, the Justice on Wheels program, and where the courts themselves go to the localities and conduct hearings on buses, especially in areas where court facilities are inadequate. And so far, a total of 7,800, one to the other, and then the friend not being able to make good on the promise to pay. These are actually small civil claims that can be immediately disposed of. We have established a small claims court, and the jurisdiction of these small claim courts is up to 100,000. We're going to push the envelope further, try to find out if we can increase the jurisdiction even to double that amount. You know why this is important is because the evidence is just by affidavit submission. And we have facilities who can that will even help the parties draft the affidavits that they need. Within a period of 6 months, our experience so far is that no later than 6 months, the whole thing is concluded. But we want to up the ante because if we can conclude the submission of the affidavits and the counter affidavits in as little as 1 to 2 months, we can have decision in 1 day. Now, if we can even have a special focus on the situation of OFWs. Just imagine, OFWs have usually 2 weeks to 1 month home leaves given them. For them to be able to avail of these processes, we will try to do that. Now, one thing that is happening right now in 2 courts in Quezon City, 2 branches, the resolution is given to the lawyer a few minutes after the order is pronounced in open court. That is quite revolutionary in my mind. Just imagine, for one to experience, pwede pala yun, hindi pala hinihintay na itatay pa, ibubulsa pa sa envelope at i-mail pa ang mga orders. But right now, people, especially judges, can make commonsensical solutions and can really show utmost sensitivity to the fact that many litigations take too much time and therefore are unduly burdensome to the people. Now, this is all backed by a very ambitious enterprise information system program that the court is going to be pursuing over the next few years. As you can see, we have been focusing on game-changing reform programs. Some of them are actually low-lying fruits, like the e-Subpoena and the e-warrant system. It is such a common-sense solution to a problem. But the immediate impact of having these common-sense solutions already brought to the people and them seeing that come alive is actually very meaningful, in my view. It is as important as the other priorities that have already been identified by government. And if I may be allowed to say, even more important than some of them. If we can see the paradigm to be in terms of supporting judicial reform equals upholding the pursuit of Filipinos for economic opportunities, the practice of their liberties, and their ability to lead productive and happy lives, I think you cannot but agree that this is the time when we need to all come together and try to promote and support the justice sector. And therefore, I find these occasions, few as this may be, to be very helpful. And I thank you all for coming here. And rest assured that the pledges that we had made when we first took the mantle of leadership in the court will be pursued relentlessly, day by day, without us missing a step. Thank you.
Maraming salamat, Madam Chief Justice. Ngayon mga kaibigan, nais po namin ipakilala mga kasapi ng media na magtatanong kay Chief Justice Sereno. At isang news anchor at program host sa UNTV, Attorney Reggie Tongol. Inaanyayahan po kayong sumali sa diskusyon sa pamamagitan ng Twitter. Sundan lang po ang SCPIO Twitter account at SCPH_PIO at mag-post ng inyong mga katanungan o komento. Mangyari lamang na gamitin ang hashtag AskCJ. Tayo rin po ay napapanood ng live sa iba't ibang stasyon ng TV at radyo. Narinig din po tayo sa DZAR, DZXL at DZRH. Ladies and gentlemen, the panel members are given 2 questions each. They may choose to ask both during the same round or choose to ask one question for each round. Time permitting, we will take questions from the public through social media. We will now proceed to the panel. The order of questioning has been predetermined by lottery. Ang unang magtatanong po ay si Buena Bernal from Rappler. Buena.
Hello. My first question, Chief Justice, deals with relationships within the judiciary and its co-branches. I'd like to know how you propose to deal with a deeply divided court, and I use divided, or I characterize it as divided, given recent events, including the appointment of Justice Francis Hardeleza, whose nomination you previously blocked, and
duty, then you must stop at upholding it. To add on to it is something else. Now, within the judiciary, we have always had divided cases, but these cases, if you are going to track, are the exceptions rather than the rule. In more cases than not, even in the most controversial cases, you would either have consensus or near unanimity. Now, I think it is incumbent upon any member of the judiciary, of the JBC, whether that member is the Chief Justice or a regular member appointed to represent a certain sector by the President, the Secretary of Justice, or the representative of Congress. It is the constitutional duty of that person, the moment that that person is convinced that there is a basis to raise an objection, to raise such an objection. And it is incumbent upon the Chief Justice to show that there is no hesitancy to preempt such a question. Now, I cannot give an opinion on another person's opinion, even if it's the President's, because out of respect for these important public officials, I will have to reserve opinion or decision-making to the time when a justiciable issue is already before the court. Thank you, Leah.
Thank you. You're asking your second question now. Okay.
For my second question, do you somehow feel pressure, considering that even the President himself has made his parang reactions, somewhat he's disappointed with the recent decisions of the Supreme Court? Have you ever felt pressure as an appointee of the President? And ma'am, where does your loyalty lie?
The pressure on the Office of the Chief Justice is always enormous on a daily basis. That is why it is important for me to uphold the independence of my office on a daily basis. It is important that people see that the Chief Justice has the Constitution first and foremost on her mind, and her devotion to duty and her loyalty to country is.
How can the Supreme Court uphold its independence when it seems that the two branches of government are ganging up in the judiciary? Like dun sa Congress, they have an ongoing investigation on judiciary fund, and Executive Pinoy seems saying that Supreme Court is meddling.
Can I, what did you say? How far can or how far will the Supreme Court uphold its independence?
How far can the Supreme Court uphold?
Meaning, how much leeway or what are the mechanisms or structures that the Constitution has built in for the defense of our independence? Actually, if you're going to look at how judicial processes are enforced, we do not even have the muscles to enforce our decisions. Sheriffs can to a certain extent, but when there is physical resistance, then you resort to seeking the assistance of the police forces who have the power to bear arms. The state monopoly and the power to bear arms is vested in the executive department, not in any other department. So that is already an objective limitation. The Constitution says, sinabing wala kaming ipapadalang opisyales. Hindi yun ang sinaad ng aking dalawang liham. Lalo na doon sa aking pangalawang liham, minabuti kong ipaliwanag na mayroong dalawang tinutukoy ang mga kongresista na maaring masabi nating mga tanong na angkop na argumento sa motion for reconsiderations na nandoon sa DAP cases. Ngayon, alam mo naman ang DAP cases, consolidated petitions yan. Ang unang tanong na ito ay, totoo nga ba na ang hudikatura ay gumagamit ng kapangyarihan ng ng legislatura pagkat minarapat nilang sabihin kung ano ang mga sources ng Judiciary Development Fund. In other words, ninakaw o ginamit namin ang legislative power na wala po sa amin. Kasi sinabi, lalo na po doon sa pagbigkas ng pangungusap na yon ay dinikit po nila sa ibang mga mga salitang na kikita rin po natin sa DAP decision. Ang pangalawang sinabi po nila doon ay, ang hudikatura daw ay gumamit din ng interbranch transfer. Pagkat mayroon daw po silang pondong itinutulong, thirdly pa nga po, ginagawa at meron po kaming pinopost. Hindi po, may quarterly report po kaming ginagawa at may annual audit ang COA na ginagawa. So wala naman po kaming tinatagong kababalaghan tungkol sa JDF. Ngunit angkop po ba ang panahon na isama po yung mga legal na question na yan sa pagtukoy kung ano nga po ang nangyayari sa JDF? May tamang panahon po. Hindi po ito pagtatago. Ito po ay nag-aayos lamang ng mga bagay na dapat unahin namin muna, which is yung motion for reconsideration. Pagkatapos po nan, haharap na po ang opisyalis namin sa JDF. Wala po kasing misteryo talaga sa JDF. Salamat po. At yun naman po ang sinabi ng COA. Walang fraud, walang illegality. Meron lang po silang dalawang puntos na gusto nilang tukuyin namin. At tinutukoy na po namin yon. Salamat po.
Thank you, Joseph. Next round? Okay. Next to us will be Edu of Philippine Star.
Good afternoon, CJ. Yeah. Despite the annual releases of SALNs of justices since you assumed office, there's still a continuing clamor. There's still a continuing clamor for transparency of wealth of the justices. So,
kaliit po ng net worth. Pag po ba siya kumain sa isang hotel, pagdududahan nyo na po yan. So ano po ba ang pagbatayan natin? Bakit nandyan na ho ang means? May waiver naman po kami. Kung talaga may honest to goodness investigation, ang ombudsman naman po can conduct more discreet investigation. Ano po bang impormasyon pa ang kailangan na maipakita namin upang malaman na wala naman ho kaming gustong itago na sinasaad sa batas dapat naming isiwalat, no? So, alam niyo ho, simula nang umupo kami, humingi ho ako ng mga panukala mula sa mga tao kung paano pa ikumbinsi ang mga mamamayat natin. Ang proseso ng paggagawa ng desisyon ay may dinadaanang scientifico na pamaraan at nakita nyo na po yun dun sa pagbubukas ng aming court proceedings. Kasi ang live na po yung audio streaming natin. Pero hindi ko na po maintindihan, maisip pa kung ano pa ang gusto nyong lifestyle, aming limitasyon. Wala nga ho kaming NBI Wala ho kaming CIDG, wala kaming forensic team. Pero sa liit ng kakayanan naming mag-imbestiga, ginagawa po namin yung bagay na yon. Kung maaari lang hong tulungan nyo sana kami. Kasi ang hirap naman ho, anong masasabi ko kung ang isang tao malaki ang net worth at ang isang tao maliit ang net worth? Hindi ko ho masasabi na yung mas maliit ay mas honest at yung mas malaki ay hindi. Hindi naman ho ganun yun So, kayo na po ang magsabi sa amin ng mga suggestions pa. At the same time, hinihingi ko rin po ang pagiging sensitibo nyo na ang tingin ko na nga po ang mga justices na ang talagang very transparent na in that regard, no? And Pia, and I hope you don't mind, I go back to one of my public speeches. I said that the reason why we are not able to exploit to the maximum our ability to build ourselves as a nation is that we have not paid sufficient attention to constitutional processes and to the constitutional roles that are assigned not only to the two most powerful branches, which are the executive department and the legislative department, but also the judicial department and the constitutionally, fiscally autonomous agencies, the three constitutional commissions, the COA, Civil Service, and the COMELEC, and especially also the Ombudsman. In other words, if we had public servants who are professional, now, I refer to the judiciary and these four that I mentioned as the professional accountability officers, meaning of all the people in government, we are the ones who are supposed to be the most depoliticized. That's why the terms of the commissioners of all the three constitutional...
Question will be asked by Mark Meruenas.
Hello. Chief Justice, yes. I know there's already an ongoing probe on this by the Supreme Court, but my question slightly touches on the issue of Sandigan Bayan Justice Gregory Ong. As a result of the controversy, judges are currently being investigated right now, and there are even reports that there is a recommendation for his dismissal. How do you, as Chief Justice, intend to clean the image of the judiciary in light of these events? And do you think internal investigations such as this is enough?
Well, you also had several questions there, Mark, but I think that the idea is how do we move forward, considering that there is an impression that there is corruption in the judiciary. Corruption has always been alleged in the judiciary, and some of those charges have been proven. Now, this therefore means that I am not a Chief Justice that wishes to uphold the judiciary by going into a state of denial. I face facts as they come. The public must expect relation to why our society is the way it is. And maybe we can say that because we have decided to really turn around, then we can influence really this country for the better and other sectors as well. So I'm taking this chance, Mark. I'm not afraid because more investigations of this type will send fear in the hearts of some people. They will complain, what kind of a leader is this that will allow the institution she leads to go through this very awkward and painful process? But how else can we turn an institution around? I know of no other way. No institution has sufficiently progressed by keeping its secrets unresolved. There must be a reckoning, Mark. So that is what I am trying to impress on all. But at the same time, I have to understand that the judiciary is a very large ship. I had already adverted to that. You move it too much, too abruptly, and it has a danger of killing over, killing over and drowning its passengers. So I have to be careful. That is why the fact-finding committee of justice...
An encoder who was suspended, but the three other justices who had been investigated, we don't know of the full details. So why should these internal investigations, ma'am, be kept secret?
I'm sorry, Malu, I don't know who these three other justices are. In the Supreme Court?
Well, the reports have it that Ma'am Arlene was dealing with four judges. Not justices, four judges, I'm sorry. And
four judges, lower court judges.
That's right. And that there are two other fixers, according to the court administrator, who worked the rounds of the judiciary.
The two other names. I'm sure that Attorney Te has already given you the text copy of our report. And there is already a rundown of how many judges, non-judge personnel, lawyers we have dismissed from either the judicial service or from being members of the bar. So the drive to weed out those against whom cases warranting dismissal have been really pursued with vigor. That is true, and you already have a list. But you are actually asking us to justify the sensitive matter by which we are handling these investigations. Well, it had faded. And it had faded into something that was just suggestion. No? So it is because of the fact that we do not want to destroy lives that we are careful about it. Not that we are going to cover up for any crime or wrongdoing. You can be assured of that. And at the proper time, the results, even of the administrative cases, will be made public. It's just that the process, we are being very careful of the process because of the number of personalities involved. The fact that their careers are also important to us because of the fact that in some of the allegations,
reasonable perhaps to ordinary citizens who would have to have their request notarized and have to submit articles of incorporation, barangay certificates, etc., and actually argue for the merit of the request. And for that matter, the case of the BIR also that had requested, it's a government agency. I don't know why, well, except for the Supreme Court, the House of Representatives, it must be said, doesn't also give copies of its SALNs, only a summary. So you're far better than the House of Representatives in that regard. But question is, the Constitution...
Yes, it's just been 2 years. For all you know, you need consensus. From a period in which there was non-disclosure to a period of disclosure, every step has to be fully discussed and debated. Now, Edu is trying to push the envelope further. He's trying to talk about a lifestyle check. Some justices are okay with the lifestyle check. Some may not be comfortable with the lifestyle check. In any case, whatever rule we will have to generate will have to apply to all. So you have to build consensus towards that. Maybe the issue is really you're a bit impatient with... Now, with respect to Marlene, I don't think she has any idea that so far all the personalities are the only relations that have been discovered so far are trial court judges. But she doesn't ask for their SALNs. Only the SALNs of 3 collegial courts, some 2 of which are heavily hearing her cases, one of which is not. And then you suddenly tell these magistrates who are hearing your cases, you give me your SALNs because I'm conducting tax fraud investigation. Now, to be accused of being the subject of a tax fraud investigation is a serious matter.
Justice Reporters Organization or juror, we believe that these questions are very relevant, considering that you have stated in your message sent to us via email by the SCPIO that you are working hard to regain public trust. Our first question, ma'am, from the juror is, Associate Justice Arturo Brion, in his concurring opinion, has accused you of manipulating the JBC processes. This pertains, ma'am, to the case filed by then Solicitor General Francis Hardaleza. His exact words, ma'am, are, CJ Serrano manipulated the JBC processes to exclude Hardaleza as a nominee. The manipulation was a purposive...
Maybe that rule is related to the question that you are raising. And perhaps there is no response that should be made at this point.
Thank you, Cecil. Second round ka na? Oh, okay. Next question will be asked by Attorney Reggie Tongol of UNTV.
Good afternoon, ma'am. Ma'am, earlier you told us that the judicial reform that's being implemented under your watch is being mostly funded by US aid and possibly the European Union and other funding sources. Why do you think that
the budget window for increasing help to the judiciary is disproportionately not favorable to the judiciary for reasons that are not very clear to us? And that is what I was saying in my initial statement. investing in the judiciary is an investment proposition. If they're willing to take on a lot of financial burdens by increasing the budget to 15%, why are they only giving a 4% increase to the judiciary? I think it is wrong. I think it is wrong for them to miss supporting reform if the people can have their voices heard that we think that giving ₱1 more per million or X more to the judiciary doesn't really hurt economic development. In fact, it can spur economic development if you are really going to see dramatic improvements. Because if the development money that we are able to ask to be used to support the judicial reform programs run out, do we stop? In other words, Reggie,
in Congress really strike at the heart of expanded judicial review. You refuse to answer political questions. I perfectly understand that. So this question really pertains on how would you defend expanded judicial review, the expanded judicial review powers of the Supreme Court to better explain it to the...
With grave abuse of discretion. Now, that was really expansive language. That's why you have the term expanded judicial review. It limited to only a very few questions. The questions that genuinely can be invoked under the political question doctrine. Ang problema, paano po namin ipapaliwanag yon? Dati po, noong panahon ng martial law, may mga petisyon na dumating sa Korte Suprema. Hinihingi po nila ang paninimbang ng Korte Suprema. Discretion ay may mga hangganan. Grave, whimsical, may maring na requirement po yan. Kailangan, hindi naman po yung mga ministerial, yung kailangan po yung mga quasi-judicial agency. May mga technical requirements po yan. Hindi ko na anahin kasi masyadong masalimuot po tayo ngayon kung papasok pa tayo dito. Ngunit ang sinasabi po natin kasi ngayon is yung tinatawag mong balance of power. Separation of power, ito ang hudikatura, ito ang ehekutibo, at ang legislatura. Naiintindihan natin na dapat hiwalay ang mga yan. Kailan ba nang hihimasok ang judiciary sa gilangkas, sa kasaysayan, at sa lingwahe ng utos sa Korte Suprema na hindi na siya pwedeng magtago muli? Dadalawa po ang maaring approach ng Korte Suprema. Umatras o umabante. Ngunit pag-isipan po natin, ang pag-atras at pag-abante na yan ay napakaraming steps, more than 1,000 steps, because there would have been more than 1,000 cases where this jurisdiction was decided on. May mga patan. I think the court has every duty to weigh heavily in favor of the liberties of the people. Now, when it comes to economic policies, shouldn't we also ask the question, but are the policies that have been laid down by Congress sufficiently appropriate to the constitutional design? Or have they been clarified sufficiently so that there will not be a clash between the individual economic rights of those who will be... Is it a matter of the court being asked to stay in its place? Then I think everyone must reflect on what it means to ask a court to stay in its place. In the concept of the advancement of liberties in any country, is that what is being meant? I don't know. You have to continue the debate, but we cannot. So I hope I have answered your question by describing a process, by asking questions that should be factored in the debate. Thank you, Ina.
Thank you, Chief. The next question will come from Dean Mel Santa Maria.
Hello. Chief Justice, Chief Justice, ang mga taong bayan ngayon, ang kanilang persepsyon sa Kongreso, sa Korte Suprema at saka sa Executive, talagang medyo nagkakaaway-away sila. At kamakailan nga napakinggan natin si Pangulo na talagang merong mga matatalim na pagpupuna sa Korte Suprema At kayo nga, ang sabi nyo nga ngayon, hindi nyo naman binabasahan kung ano man ang mga sinasabi ng ating presidente. Pero honestly, Chief Justice, sa tingin nyo ba, sa tingin nyo ba, sinasadya man o hindi, may contribution ba ang inyong mga tugon o di pagtugon bilang maestrado ng Korte Suprema sa paglalala nitong persepsyon ng taong bayan dito sa atin ngayon?
Una-una, honest naman po ako eh. So siguro gusto niyong sabihin candidly, ano? Apo, no. Sinagot ko po si Miss Hontiveros kanina. My words will always be measured. Because I think that is the role of a Chief Justice. And are you basically hinting at the need for us to send words of appeasement, words of clarification? But you see, the Constitution has designed it that the court only responds when we issue the final resolution on the motion for reconsideration. It cannot be otherwise, Mel. You cannot have a court simply because there is noise about its decision, coming up with a statement seeking to clarify a decision outside of the normal process. Because as you know, that there will be 1,000 issues that will also generate that kind of controversy, and we cannot be responding in that way. We cannot start now, and we should never start. Otherwise, we do not allow the ordinary, constitutionally ordained process to really take shape and help stabilize our country. What I'm suggesting is for people to wait. Perhaps waiting helps. If people can wait more patiently, then perhaps there will not be this, what you call, perceived problems, no? I hope that people will appreciate the fact that when a decision is made, it is always for the long term. It is to survive presidency after presidency after presidency if it involves a use of a presidential power. And it is from that long-term perspective that the process should be allowed to really take shape the way it should take shape. Should not be episodic. Here you have a sudden movement, sudden convergence of complaints, and then you react. Because we must always look at the frame of the Constitution from a long-term point of view. Because a decision on this matter will also inform and guide future actions. That is why everything has to be deliberate. It will help if people can wait.
Thank you, Chief. Thank you, Mel. The next question will come from Red Madrid of Business World.
Hello. Good afternoon po. The Judiciary has asked a 2015 budget of 32.7 billion in a bid to further strengthen its modernization program. But the DBM has only allocated 20.28 billion, or a cut of more than 12 billion. So, how contented are you with that allocation by the DBM? Contented are you with that? And how are you going to push through with the reforms given a limited budget?
Red, I'm not content with what they gave us. It is, I am not content. That is why we were trying to make a strong case. We had distributed the slides to you. I think you fully know where that money is going to. How do we continue with those reform programs? Well, it will be difficult actually to sustain them in the long run. That's why, Red, I don't I don't want failed expectations. We don't want to stop reform steps that are already taking place to stop midstream. I have asked for the finance people to give me several financial programs that will require us to continue advocating for more financial support. And I hope that in this regard, at least in this regard, we can continue to be engaged with the rest of the community. And I hope also to touch base with the business community to impress upon them how important the steps we are taking already is on helping even the investment climate. And I had already spoken specifically of the continuous trial system and the e-court system and how it really will help expedite the resolution of cases. And if that can be seized as a key agenda of several sectors, that will be most helpful. Thank you.
Thank you, Chief. Thank you, Red. The next question will come from Ray Panaligan, Manila Bulletin.
Good afternoon po, Chief Justice. Ito po ay tanong kaya po Pilipino. Tanong po ito ng aking mga kababayan sa inyo. Ano po? Bata pa raw po sila, laging ang pagkaalam nila ang Judikatura, ang Judiciary, ang pinakamahinang branch ng government. Totoo pa raw po ba ito?
Pwede kong tanungin siguro siya, ano ibig sabihin mahina? Mahina sa budget po, wala talaga po tayong mahina ang tuhod, mahina ang...
Ganito po.
Anong ibig sabihin po na mahina?
Chief Justice, sabi po kasi, and I heard it from you earlier, sabi po na ang executive, merong sword, merong PNP to implement everything. Ang Congress, siya nagdi-decide ng purse o pera, nagagastusin. Samantalang ang Judikatura, ang Judiciary, yan lang nag-interpret ng batas na sinasabi nilang ito ang pinakamahinang branch, the weakest branch of government. Although they are co-equal, but the weakest. Tama pa po ba yun? Yan po yung tinatanong ng mga magsasaka sa amin. Tama pa po ba na weakest branch of government ang
maganda hong tanong sa inyo, bakit yung magsasaka pa sa Mindanao ang interesado sa tanong na yan? No? Tatapatin ko po kayo na mayroon po kaming problema sa pag-enforce ng writs namin. At sasabihin ko po na sa Mindanao may mga writs po kaming hindi ma-enforce. Baka yan po ang nakita ng magsasaka na nakausap nyo. Halimbawa po, sabihin namin na sa isang lokalidad, mayroong kailangang arestuhing tao. Hindi naman po kaya ng mga sheriff namin gawin po yan, kundi kailangan po niya ang tulong ng lokal na pulis. Paano po kung hindi ganado ang lokal na pulis? Natulungan kami sa pag-aresto ng isang personalidad. Maari pong dahil malakas politically siya sa lokalidad na yon. Na po, ang sinasabi ko po kulang po kami ng armas, wala po kaming kapangyarihan sa lugar na yan, at wala rin po kaming pera, wala kaming kapangyarihang i-determine kung magkano ang pera namin. Ngunit ang hula ko po ay tinatanong niya, ngayong nasa sentro ng usapin ang Korte Suprema at may mga sangay ng gobyerno na nagsasabing bakit siya nasa sentro ng usaping yon. Mukhang hindi siya totoong mahina, kundi malakas siya. Yun po ba?
Oo nga po, Chief Justice. Ang in-expect po ng mga magsasaka na sagot nyo, yes or no? Mahina, yan, totoo po ba na ang judiciary, ang pinakamahinang sangay ng ating pamahalaan? Ang sabi po nila sa akin, yes or no, Ray? Yes or no?
Okay. Ganito po. Sasabihin ko naman po ito. Kung ang hudikatura po ay malakas kung naniniwala ang taong bayan dito. Malakas po siya. Kung wala pong kumpiyansa ang taong bayan sa hudikatura, Ang sagot po sa magsasaka sa tanong nyo ay hindi po siya malakas. Yun po ang aking sagot.
Ganun po. Anyway po, kasi may follow-up question po sila.
Ray, is this your second question
Yeah,
already?
second
Ito
na lang.
Okay, sige.
Second, sorry po, Chief Justice na po. Kasi po nung bata pa sila, talagang pinakamahinang branch ng government ang judiciary, no? Ang tanong nila po Ray, alam naman natin nung araw pa, yan lagi ang sinasabi ng mga lawyers, politicians, justices, kung pinakamahina yan, ano pang power ang ikiklip ba? Sa Supreme Court o sa Judiciary? Ano pa? Pinakamahina na nga yan eh. Anong power pa ang dapat i-clamp down, i-suppress, limitless ba? Natulad ng mga naririnig namin sa radyo at napapanood sa television, yun po ang simpatya ng mga magsasaka sa inyo, Chief Justice, na tinusundan lagi ang ginagawa nyo araw-araw.
Salamat po.
Salamat po.
Salamat po, Ginoong Ray. Nakakatuwa naman po na nakakapagbigay kayo ng feedback sa akin mula sa magsasaka ngayon. Sa Mindanao, sabihin niyo ho, pag bumisita po siya sa Padre Faura, maaari po niya tayong bisitahin.
Sige pa. Okay. Sige. The next question will be asked by Teresa Serrano of FOCAP and Associated Press.
Hi, ma'am. I have the misfortune of asking the last question for the first round. So most of the questions I have in mind have already been asked. But can you tell me, do you think the constant criticisms by the President and Malacanang on the recent Supreme Court decisions have somehow eroded the Supreme Court's credibility, independence as an institution, or have they tainted the judiciary somehow? And what would be the repercussions for the nation?
Alam niyo po yung, di ba ang mga polling firms, ang nasa science of measuring perception, no? Since credibility is a function of the public's perception, I'm not in the science of measuring perceptions, I do not know the answer to the first subpart of your multi-part question. So I don't know whether it has eroded the credibility or the perception. I think the better answer coming from me would be only time will tell. Only time will tell. Now, is that the complete question that you had, or there was a second part to that?
If these criticisms have eroded the institution's credibility or independence, what would be the repercussions?
The repercussions. I hope that people will see that it is in their interest to promote a strong and independent judiciary. I mean, the cliches about, some call it cliches already, about being the last bastion of democracy, the court of last resort, etc. Those have been said often enough. But I don't know whether people understand that even in their ordinary goings about, the independence of the judiciary will be able to help determine whether the opportunities in all areas of life will still be there in favor of its citizens. In other words, what redress will the citizens have if you have a weak judiciary? I think people should not welcome that possibility.
Thank you, Chief. We go into our second round. The first question in the second round from Buena.
Chief Justice, my second question is more personal and involves your position of power. we've seen the dangers of an overly powerful Supreme Court. The position of Chief Justice can be abused, as we've seen in the past. But at the same time, we've seen the dangers of a weak Supreme Court. Beyond upholding the Constitution and beyond abiding by the constitutional design, more particularly, personally as an individual, how do you balance the extremes between having such a powerful position, but at the same time, making sure that you're not overstepping your bounds?
Okay. May I just read some excerpts I delivered in a speech in July of 2012 when I was just being considered. It was a speech I delivered before the IBP, and I think from Rapper, Purple was there. Okay. After going into some lengths about my background, which we were asked to present as candidates, I said this: I have no hidden personal agenda, and I have no interest in creating one. I simply see my role as a judge as a humble yet highly edifying one. We justices of the court are to simply apply the law to the truth that is staring us in the face after much searching by the mind and after much reflection by the heart. It is a humble role because we can go no further than what the Constitution, the law, and the rules of statutory construction allow us. We do not replace the shared values of the community with our own. Yet, our role as judges is a highly edifying one to society. For in invoking the lofty vision of the Constitution, in painting before our people the prospect of a more just society, in living upright lives in order that we can be in a position to tell our people, this is the truth, this is the right way, this is the path, we edify our society and build for future generations a foundation that is built on solid rock, not on the passing fancies of politics, but on the more enduring values of our people. So in order to balance this, humility is key. It requires first a mindset that is fully committed to upholding and searching for the truth. And then, of course, before you come to that position where you are even allowed to decide what the truth is, you must have had the necessary competence and training. But everything is a matter of trust that is just vested in us. We are not really, there is no entitlement to this position. I have no entitlement to this position. This is but a sacred trust. And if that mindset is constantly kept, then it will definitely be constrained by a healthy measure of humility. Because what can you do? You can shape society only so far, and you hope that you are sharing it in the right direction. You always hope that you are not intruding into areas of expertise that were never yours to enter into in the first place. You are always constantly reminded that a policy in Congress like the reproductive health law had been debated already for 14 years. And that was what I said during the oral arguments. So there must always be humility to keep us in check. This is also consonant. This also is consonant with my response to Pia when I said that basically you have to have measures that are really in place to keep you balanced. That's why I do not try to add to the noise, and I always measure my words. Then people will start to believe that the value of professionals like us, non-political animals, is really key to marching our society on a stable basis. So that is how I try to arrive at the balance buena. Because you are talking about two extremes, humility is the key.
Thank you, Chief. The next question in this round from Tara.
Hi, Chief, right here. Ma'am, you talked about the lamentable levels of funding for judicial reform in the judiciary in general. So I just wanted to touch on the Judicial Development Fund. How far will the Supreme Court go in defending this fund, and what's your response to allegations, essentially from allies of the president, that you had committed some impeachable offenses in the disbursement of this fund?
You know, in response to the question of Joseph, I already said that I cannot respond beyond what I had already stated in my 2 letters. In my 2 letters, especially the last one, I emphasized the fact COA has not found any fraud or illegality. And it is the COA which is the constitutionally designated body for these kinds of matter on financial irregularities with respect to public resources. Okay, that was the first. And then I said with respect to efficiency observations of COA, there were 2, and we are already addressing that. Now the third, that there are impeachable offenses that have been committed, that again has to await the resolution of the motion for reconsideration. So what those are, I actually don't know. And I haven't really, other than some, I really am not enlightened on what they are really referring to. But I'm actually putting aside that question because we have first things first. We resolve the MR and then we try to address what their claims are with respect to the Judiciary Development Fund. We are ready. The moment that the MR is decided, we will be sending our officials. The public can be assured about that.
Thank you, Chief. The next question in this round from Juliet.
Yes. Ma'am, before kasi nung umupo na po kayo, pinatupad niyo po yung dignified silence. But now, considering na ang dami po mga criticisms on dito po sa Korte Suprema, pananatilihin niyo pa rin po ba yung dignified silence na yan?
Si Attorney Ten naman, I find him quite responsive. Diba? I mean, kailangan ba ako lagi, Juliet? Ang dami kong trabaho. Kung maaari naman si Attorney Te, kita mo naman na he's a very pleasant person. So he's a very intelligent person. I think you can approach him anytime, Juliet. So yung information gap, kung meron man, pakitanong na lang sa kanya. But the Chief Justice cannot engage the way politicians can engage. You know.
Hi, CJ again. I'd like to consider this question as a personal question. With the perceived division in the court, can you say that you are in control of the Sereno Court, and how does the dynamics in the court in the current composition affect your reform agenda?
Edo, I think you've been observing the court for quite a significant period of time, and you have to agree that the pace of reforms is fast, and the pace of decision making is also fast. And when I say that we have not missed a step and we don't intend to miss a step, that has been consistent. No, there has always been a quorum. The courts have always met. The agenda plate is always finished. The reforms are moving forward. Meetings are always consistently being called. I don't see any obstructionist in the reform agenda. So the question is, where did the idea that the Chief Justice must control a court arise from? If you respect each member of the court as an individual conscience that must decide independently, then control is not an appropriate adjective or verb that must be sought in trying to promote the leadership of the court. In fact, it is anathema to the individual conscience. So that much I can tell you, Edu. Now, with respect to the tradition of calling a court by the name of the Chief Justice, it also has a tradition, some traditions in the U.S. You can look at the Chief Justice John Roberts and how he almost always presides over a divided court in the most contentious issues where the vote is 5-4. So you have different levels of perception and different angles. The question is, what is the angle that where the proponent is coming from? Did they think that there should be a capture of the court the moment that a new Chief Justice is appointed? I think that is a dangerous proposition, and it is really anti-democratic. You know, leadership must be exercised in moving the agenda of reform forward, regardless of the final voting outcome. And I will not shirk from, as you can see now in the various trial courts, especially here in Metro Manila. Can you just imagine, I was asking the trial courts of Quezon City, I will ask you, can we move the envelope further? Can we push it further? I've already asked you so much. We went through a very difficult e-court transition system. We are basically dropping the manual system and letting go of all those psychological handles by having papers still with you of your records. Or can we go there and, in fact, push the envelope further by saying we can go and conduct continuous trials? And you know their answer? Why not? And this is what I want the new breed of lawyers and judges to be. The why not judges and the why not lawyers. Why can we not make things better? And you know, if you just try to conform to the old boys club, what is the expectation then? That there is politics, there is cotton. What are the things that will be asked of someone who is not willing to stand by her convictions? That is not a good message. The message should be people must stand up for their convictions, regardless of inconvenience, regardless of the names they will be called. If it's a matter of conscience, then you must stand up. And that is what I am banking on, that my leadership will show.
Thank you, Chief. The next question from Pia.
Chief Justice, kanina po ang sabi po ninyo, ang hudikatura ay malakas kung naniniwala ang taong bayan dito. And you also said, I don't know if it, meaning the criticism, has eroded that credibility and only time will tell. However, I'm sure you are, or you must be, you meaning the entire court, you must be getting feedback about how people feel about and towards the Supreme Court. And I would like to ask if you can share that with us. And if this feedback is positive, then why doesn't the High Tribunal take the even higher ground, lead the way, shine the light on itself? For example, take up the challenges of Malu on the painless release of SALNs and opening the Leon Fact-Finding Committee probe. Even yung sinasabi po ni Edu kanina about the lifestyle check challenge.
Or not. The intrusiveness into the private life of a person in my position is quite enormous. Hindi biro yan. Now, the question of whether all the other justices of the High Court, the Sandigan Bayan, the Court of Tax Appeals, etc., are also willing to go through that is something that must be subjected to constant dialogue, especially, and I'm very concerned here about the Sandigan Bayan justices, on whom even deadly pressure can be imposed, and our lower court judges. I am not publicizing the threats to life that they are getting, but they are, and some of them have already been killed. The fact that we cannot even provide for their safety, and we immediately say there is no more any cloak in your privacy, nothing to protect your privacy even, nor that of your children, that of your assets, your location, what the model of your car is, how much your cash is. That is a question that is not easy to resolve. And the constant counter question that the judges and justices are throwing back at me is, If you are pushing for a more transparent lifestyle, is that also going to take place in the other agencies of government? Or are we the only ones who are already being subjected to daily pressure in connection with the judgments that we are going to produce? And on top of that, make even further disclosures, even of our personal circumstances. And that is not an easy question to answer. So it must be the product of an intense process of consultation. Now, shining the light, however, does not have to stop with the SALN, more further disclosure and the lifestyle check. It is just two. These are just two tools that are available. Attorney Teddy and I and other justices have tried to discuss ways of making things more transparent, even with respect, for example, as you have seen in the JBC interviews. Our questions have been forthright. If not, some are saying un-Filipino kasi diretsahan nga yung mga ibang tanong namin. So if we are going to try to increase more rigor in the process of selection, and in the process of monitoring our judges, and in the process of discussing even our budgetary requests, are these also not light shiners that you also need to credit us for? Hindi naman limited ang tools sa dadalawa lang eh. Gusto namin kasama kayo sa budget. Gusto namin kayong kasama sa rate of disposition. Gusto namin kayong kasama sa how we are trying to address operational problems. Like, I have been pushing for a GIS that will be open to the public, where every locality will already have accessible data on how many judges, prosecutors, POW lawyers there are, and including the members of the IBP per location. I am also asking the IBP to already by next year have a website where the role of attorneys are there, if possible their pictures are there, the status of their membership in the bar, so that you don't have fly-by-night practitioners. We will also have access to information on our judges, and they are already accessible in the OCA website. More and more information is going to be uploaded on internet accessible mechanisms. These should also be credited. Hindi naman yan lang dalawang issues na yan. And the ombudsman is there. So, ano pa po ang tinatago namin? Bigyan niyo po sana ng espasyo ang judges to talk about their own personal lives. Kasi mahirap po eh. Remember that I spoke about having to lead a semi-monastic life. Because you are supposed to minimize your political and social contacts. So you are already closeted within that world. You try to do that, be as professional as you can, so that even the appearance of impropriety will be far off, a far off possibility. But then at the same time, you know that even the identity of your assets are all identified. Andyan yan masyadong bukas. So, kailangan mo naman silang sabihan, there will still be a measure of comfort for you. You can still lead a normal life. Hindi naman parang yung buong mundo ay pumasok na at nang hihimasok sa buhay mo. That is what I'm asking you to balance. Ang dami-dami na namin ginagawa, ang dami-dami na naming disclosures. But with respect to this, give a little more period for greater dialogue among our ranks.
Thank you, Chief. Next question will come from Mark.
Ma'am, somewhat follow-up po ito dun sa question ni Juliet. In the past 2 years of your leadership, the SCPIO has instituted reforms in terms of the working relations between the Supreme Court and the media. If I can only just ask, what do you think or what do you consider are the highlights of these reforms, and which do you consider are working and which are not working or could be considered as areas for improvement? That's on the side of the SCPIO, and on the side of the media as well, just to be fair. What do you think, if you would have it your way, what do you think the media should have covered in the past 2 years, and how would you describe the way media covered the judiciary in the past 2 years? in light of, there have been reports before and studies showing that the judiciary is one of or if not the least covered branch of government.
I started my statement earlier this afternoon by talking about the future. Now let me talk about the future and how I envision the relationship between information coverage or information outputs from the PIO and information propagation from your end is going to be in the future. In the future, this is what I hope to be. And I have asked Teddy to think of a program whereby he can go and tell the people what are the processes within the court, and especially in the Supreme Court. Because I want to minimize the areas of speculation. One problem in this country is that much of the information gets recycled on the basis of fear. There are not enough facts, so people substitute speculation with that and create fear in the process. That is why there is less ability for us to stare facts straight in the eyes and move on the basis of what really is there on the ground that can be objectively verified. If we have a time when the oral arguments in the court are at a high level, people who really already understand constitutional law, so we don't anymore go into the elementary stuff and proceed immediately to the heart of the question. A time when the Supreme Court is not saddled with 11,000 cases, 8,000 cases, but rather will be able to choose the most important cases that will define our future as a country. That time will have to come after we have unclogged many of our dockets, and we are in the process of really solving that right now, and we are really aggressively addressing that. Now, so Attorney Te must design that, and I hope that you media practitioners can also have a workshop with us on how that future can be obtained. You know why it's important? You see, when we create maps on what is legal and illegal according to statutes or what is constitutional or not unconstitutional, it is a guide for entire body politic to move along this path where things are more or less predictable and sustainable on a long-term basis. And I think it is the duty of every citizen, including media practitioners, to contribute to such a future. And for us to be able to take away the past attachment of the term flip-flopping to us. And for people to understand that a reversal on a motion for reconsideration, something as basic as that, is not a flip-flopping. It's just a simple motion for reconsideration. That being said, I also want, if the more court reporters can understand what these reform agendas consist of on the ground, if you can accompany us also when we are meeting with the judges, and if you can just see how they are devising solutions already to problems, and how the solutions are being taken out simply as an idiosyncratic answer to a particular situation, but rather it is transplanted to a rule or a guideline and being fleshed out in a resolution that will have permanence, more or less, and that will have general application, and that will be there for the template for the future. If you can join us in the journey, I will be happy. In other words, you will see, hands-on, a developmental process take place. Remember how development is perceived, no? It's from a term, I think it's a French term that talks about having something unroll and unfold. So any reform agenda has to be seen in the context of a development process, and I want you to be involved there. Because if there can be insights, and if we succeed in setting the gold standard for public service, I will humbly offer us as an example of how an institution can be transformed in the long run. How an institution can scientifically set standards for itself, targets, how it really uses government budgets on a transparent basis, how even though its most confidential deliberations are hidden from public view, there will be more or less the prima facie belief that something was decided on the merits rather than on unethical, personal, or extra considerations. That is the future relationship I want for the media and the judiciary. In other words, we, all of us here in this room, have an educational role. Educational as well as informational, of course, but we are all participants in that. My role as Chief Justice naturally constrains me from participating very actively in many of the discussions, except, for example, when I'm walking you through the processes of our judicial reform agenda. But much of that can be carried on by Attorney Te, his deputy, his people. Some of that can be carried out also by NGOs and civil societies who will agree to help us propagate these lessons on how making justice work in the Philippines can be translated into terms that can be understood by everybody. I think it is important that you see and identify for us areas of conflict of interest, that you are able to capture for us dilemmas that we ourselves are grappling with. Because it is only by shining light on that fact that we are having these dilemmas that we can most probably will be able to arrive at the wisest solution to that dilemma. Because remember that society is made up of competing interests. Among these competing interests, where should you lean towards? How do you balance things? And if you can be with us in the journey, I think it will be healthy for us in the long run. I think it will be something that can be closely watched, perhaps. Mark? Thank you.
Thank you, Chief. Cecil, second question.
Good afternoon po ulit, Chief Justice. Following the controversial decision of the court on DAP and PDAF cases, the Supreme Court has been accused of judicial bullying. My question, ma'am, is how does the court deal with what seems to be counter-bullying hurled against you by some members of the Congress and even from the President himself? I think, ma'am, this will also be an opportunity for the court to assure the citizen, to assure the public that despite the harsh blows, hurled against you, the court will not waver and that the court will not give in to political pressure.
I think I have already said in response to Tara's question or Joseph's question that I think Tara's question, I do not read anything into that. I do not read anything into that statement. It is a statement, I take it as it is, I do not read anything into that. Now, how can we assure the public that we are not going to give in to counter-bullying? Is that your question, Cecil? But you have already tried to plant a leading phrase there by saying that there is bullying, no? By asking me, how do we counter-bully or what? For me, the term bullying does not exist right now. What I am, what we are, is an independent court, and that should remain the way it is. And we are going to assure our people that that should be the way things should be seen, and we will do our best to assure everyone that our independence will be maintained to the end. And I hope we live up to the expectations of our.
If we would have heard what you could say about the case on the DAP.
Okay. Well, Reggie, on a practical consideration, I do not always have the time to write a separate opinion. And usually, I conserve it the time for when I think something must be said that has not yet been said. When I saw the separate opinions, I thought that all the things I wanted to say were already captured in some of the separate opinions. Not entirely in the main decision, because there are some points where I disagree with the text, no? But it's not sufficient for me, reason for me to write a separate one. But there are already points of view there that already capture my thoughts. So it was a practical reason, Reggie. I really didn't have the time. But thank you for saying that you looked forward to having read a separate one.
Thank you, Chief. Ina, with her second question.
Thank you. Chief, I asked this question of you last year. This is about the disposition rate of the Supreme Court. And at that time, you didn't have the data. I assume that you anticipate this question now. So I'd like to pose that question. What is the current case disposition rate of the Supreme Court? And you mentioned a while ago in your opening statement the efforts of the court for a speedy disposition of justice, but those are regarding the lower courts. There are a lot of cases still pending with the Supreme Court, some of them taking years, and I'm sure the public would want to hear from you what efforts are underway to speed up decision-making at the level of the Supreme Court.
Okay.
Thank you.
These are not steps that we had public announced before, but I think it's all right to share what we have been doing recently. If you notice that there are less and less full-bodied decisions that are coming out. Many of our cases are cases involving rape, drugs, labor relations, what else? So those three actually occupy a lot of our dockets right now. We had informally agreed that to the point where there is no doctrinal value in a case, especially if to the justice, and some may have been very, very old. When two of the oldest cases filed in 2001, I was able to dispose of in 2011 and 2012, a year and 2 years after I came in. But I saw the reason why, and I was the 15th justice to have handled that case, to have been member in charge. When I saw the records, it was already an entire trolley of our case records. You see, it's a small delivery trolley. So you can just imagine the difficulty of resolving those cases with very, very voluminous records that you have to really go through. But we are pushing ourselves to the limit. In fact, there are already complaints that when you get promoted from the Court of Appeals and you get a slot in the Supreme Court, you think that it is a promotion in your life. It's actually a demotion in the sense that you have a heavier caseload than you have ever had in your life. So only for the tough in body is the position of a Supreme Court justice. So that's happening right now. And we are already classifying the petitions that are coming to the court that need not be brought to the court. So we immediately resolve them, unlike delaying whether we need to.
Ano ba ang gusto niyong Korte Suprema in the future? Mas batang Korte Suprema o mas matandang Korte Suprema? Ibig sabihin ko, gusto niyo ba ang mga nakaupo doon mas bata, halimbawa katulad ninyo, o kaya mga mas matatanda?
Ang matanda at bata ho, ang matanda yata ang tawag age challenged, ano? Okay, ganito ho ang tingin ko, no? Una-una ho, congratulations sa anak nyo na mag-graduate na. At ang isa ko pong reforma na pinupush next year, 2015 po, ang ginagawa namin ng paraan ay magkaroon ng online application para sa bar exams. Para hindi na pupunta ang inyong anak all the way to Padre Faura para lang mag-file. Ang hinihingi ko po sa mga law schools is, I think ginagawa na ng Ateneo, i-consolidate na nila yung documents from their end. So, another efficiency that I want him to experience firsthand when he applies for the bar exam. And I also want him to consider the fact that we are already thinking of plucking out. Of course, constitutionally, it's the president who appoints. And constitutionally, it is the JBC that nominates in time. It is helpful. Physical strength is very helpful to cope with the heavy caseload that we are facing now. And you can really see a trend between those who have a lot of physical strength and the rate of disposition that they have. But if we come to a point where the caseload is reasonable, then I don't think that that is really an advantage that we are going to look for, because maybe that time will no longer be necessary for physical stamina as much as the other qualities would be, no? So the Supreme Court should be a leading light in this part of the world, because the Philippines is the only country, the only Asian country with such a strong love for human rights and democracy. And for developing countries to have a beacon that here in the Philippines, you know, we are financially strapped at this point in time. We are not very wise about our use of natural resources. We are not connected to the geographical mainland of Southeast Asia, so we have a problem really of how to make our trade more efficient. But we have overcome all those barriers. We have also overcome the fact that we have not had a long history of political will to build a country that is like that. And the Supreme Court will be a leading light in the fight for freedom and democracy without impeding economic progress and the liberalization of economic opportunities for our people. That is what it should be. And it should be an honor for your son, even in the future, to think of joining the judiciary. That is what I want you to consider. Hopefully, we will be able to prove that.
Thank you, Chief. Second question from Red.
Magandang hapon po. Simple na lang po yung tanong ko. Sabi nyo kanina, you have problems enforcing writs, especially in Mindanao, because you lack arms and power in these areas. So, nagpupush po kayo ng mga reforma, pero in that certain area, paano nyo po sosolusyonan yun?
We have already started informal discussions, and I may share this with the PNP on how we can overcome the problem of enforcing our writs in areas that are far from Metro Manila. In other words, we have court writs that don't have impact on the ground the way they should have. That's wrong by every sense. But restraining orders, for example, I hear in the countryside, it's not stopping the illegal quarrying of riverbeds. So if it's happening, is this sort of impunity, although this is not the usual way in which it is being used, should this be tolerated? This is a question I need to pose to everyone. What is the value that you are going to give to court orders? And are you willing to back up court orders? Because even the bravest judge cannot help our people if policemen will not enforce the judge's writs.
Thank you, Chief. We come to our last question from Teresa Serrano.
More scientific approach to things. Let's measure that and let's have a baseline. Now, we apply the continuous trial system. We already have the e-court system. We have a re-energized alternative dispute system. We have the e-Subpoena. We have the e-warrants. We have the automated hearing system. Now, let's look at how we can shrink that time further. I think it will be a fantastic surprise for all of us that it can actually be quite short. But the problem is, are we going to just confine ourselves with these pilot experimental projects? I don't think we should. If we succeed, I think it is incumbent upon all of us to make this a nationwide approach already. And that is where the problem of resource underfunding is most crucial. The gap must be supplied. We cannot go on and think that, oh, we can only succeed in the pilot stage. After that, we fail. If we are succeeding there, we push it and we push it until it becomes the norm. I have a very good sense that especially among the most intelligent judges and the most modern-looking of our judges, it is really going to be a surprising turn of outcomes for us. And I will make sure that Teddy makes everyone on board for them to public assistance side. No reform from the private sectors, then all the hopes of our people are dashed. Let me assure you, and let me go on record already, that our judge in the Mindanao trial case has already been given by the Supreme Court all the tools she needs to address the issues. And I have been assured and I have seen from the records that she is devoting 100% of her time to that. But how many parties are there in the Sandigan Bayan? The prosecution side is made up of both the public and the private prosecutor side. They have to have a united approach to things. The defense consists of how many sets of lawyers and how many witnesses did the court have to go through, and how many outstanding warrants of arrest are still out there. In other words, it is not an isolated, the judiciary is not working in isolation. For us to succeed, we must have very good, zealous, diligent prosecutors who are always there, public attorneys who are equally good, and private lawyers who will not resort to delaying tactics and all kinds of ambushing of the system.
Sige, ma'am. Health break daw muna yung iba.
Yeah, health break.